Welcome back to Court TV Live. I'm Julie Grant. We'll get you back to Michigan in just a moment. But first, we want to head to Florida because Super Bowl champion Antonio Brown is in court for his arraignment. He is 37 years old now and accused of attempted homicide. Police say this is in connection to a shooting incident that happened at a celebrity boxing match in Miami in the spring. The allegation is that Brown fired 2 shots, which the alleged victim claims one of the bullets from grazed his neck. The former All-Pro wide receiver appeared in court last week via Zoom, where he was released on a $25,000 bond with, of course, a GPS monitor while he awaits his trial. So let's go together into that courtroom. He's represented by attorney Mark Eiglarsh.
Okay. All right, good morning, everyone.
Good morning, Judge.
Thanks for starting again early this week. Okay, so want to take arraignments first. Start with Antonio Brown. Antonio Brown.
Good morning, Stephanie Cruz on behalf of the state. On case F2512012, the state has filed an information charging attempted second-degree murder, a felony in the first degree. The guidelines are around 48 months state prison to 30 years state prison with a 20-year minimum mandatory.
All right, and for Mr. Brown.
Good morning, Your Honor. Nice to see you again.
Nice to see you, Mr. Eiglarsh.
Mark Eiglarsh, on his behalf, Mr. Brown is present on Zoom. We have filed pleadings in this case. There he is. We have filed pleadings in this case, Your Honor. We've entered a not guilty plea, demanded trial by jury, requested all of the evidence pursuant to Rule 3.220, and we would be waiving reading of the charging document at this time.
All right, that's fine. Notice of appearance, discovery. You'll be on it.
Yes, Judge.
I am going to be actually transferring this case to Division 62. Okay.
Yes, Judge.
Which is my division, and we'll take it from start to finish.
Fantastic. Looking forward to working with you.
You too, sir. We're going to go ahead. How about if I give you a report and status date in, let's try 30 days. Are you going to, or 35 days? Let me see where we are. I'm just going to check on the calendar. Then we can just have a general discussion about how we're going to move discovery and filing of notices and keeping everything on track.
Yes, Judge.
Let's see. So, we don't know if this is going to work. We all, because it's the week of, it's a holiday week, but the 22nd of December, is that something that will work?
Your Honor, I'm standing in for ASA Rivera, who is ASA 1 on the case. I can reach out to her, and if you want to pass the case, if not, I can also readdress it with
Just let me know
before that date.
Email, make sure Mr. Eiglarsh has copies of everything.
Of course.
And counsel, will that date work for you?
Yes, Your Honor. The 22nd definitely works for me.
All right. Again, it is a holiday week, so I wanted to check with you all to get that.
I'll speak to the prosecutor, too. If for some reason it doesn't work for her, we can come up with another date and propose it to Your Honor.
Excellent. Okay, 12/22 will be for status, report, and we'll start to get organized.
Judge, I'm not sure if my client's going to want to appear. I just want to know if his appearance could be waived if we file a waiver.
Oh, yes. You filed your notice of appearance.
Yeah.
Your client does not have to be present, certainly can be present. Again, these status report dates is nothing of substance.
Great.
Really, it's more scheduling and discovery conversations. And in the next couple of months, we'll talk about how and when you all want to set the case for trial.
Sounds good. Judge, thank you so much. We're grateful.
All right, and that'll be at 9 o'clock. Thank you very much, everyone.
We'll see you then. Fantastic.
Very good. Thank you. All right.
Okay, so that was a quick appearance, but the big takeaways here, Antonio Brown potentially looking at a maximum of up to 30 years. There's a 20-year mandatory minimum attached if he would be convicted of attempted second-degree murder. His attorney, Mark Eiglarsh, there, and you heard him note, there's my client. He noted how he could see him. And I'm seeing a picture of him that was sent to me by one of our producers where you could see the whole Zoom. So he was, in fact, there. I'm not sure why this video we just showed you didn't show all of the boxes. But what we're going to do is work to get that photographic picture, get that photo of him into our system, and you can see Antonio Brown looking like he was appearing, looks like from his home, where he is on house arrest, pretrial electronic monitoring. His attorney, Mark Eiglarsh, very high-profile defense attorney. He's certainly in excellent hands with this one. Let's bring in our legal analyst guest, see what he thinks is going to happen with this case. Attorney Matt Roberts joining us, the chief trial attorney in the Muskegon County, Michigan District Attorney's Office. Matt, you know, I'm not a betting woman, but if I were, I would say this one's going to trial. What do you say?
Oh, absolutely. It sounds like this case is going to trial. As I understand it, there's going to be a claim of self-defense here. So I would expect nothing less. Certainly, I think Mr. Eiglarsh there probably didn't take this case to try to resolve it in some fashion. There'll probably be some discussions. But in all likelihood, I think you will see this case going to trial, particularly if the claim here is self-defense. And Antonio Brown's an interesting story with the NFL history that he has and some of the on-field experiences that he's had. Raise some question about, maybe some competency issues, maybe some insanity defenses could be in the offing here as well. So we'll have to wait and see how this one plays out.
Mm-hmm. Yeah, definitely. I'll be so curious. In terms of obviously we know this is a very high-profile case, Matt. In terms of the handling of things early on, Mark Eiglarsh, to his credit, has come out swinging. Come out, refuting this, speaking publicly, doing interviews, saying he's looking forward to representing him, being adamant that this is self-defense and that the facts are not what they've been alleged here. You're no stranger to high-profile cases. You've done them. As a matter of fact, we televised one of your high-profile cases that had tremendous amount of media interest all over the country with Shonda Vander Ark. Tell me, do you think from the defense perspective, I know that there are different rules for prosecutors and for private criminal defense attorneys like Mr. Eiglarsh. Do you think it's smart for him to be, speaking out and getting Antonio Brown's side of the story out there into the court of public opinion?
I would think probably. I don't think there's much to be lost by doing it. At least then you sort of frame the issue. The downside is that the prosecution then obviously gets a little bit of a window into exactly what you're thinking. But I don't think there's anything to be lost by doing that. And you're right, though, there are rules. So the reason you don't see a counterpoint from the prosecution is there are restrictions on us as prosecutors about the things that we can and cannot talk about pre-trial or pre-evidence being actually admitted into cases. So I think that's the reason you don't really see much of a response here. So it sounds like a pretty standard fare for your average high-profile case, and we'll see what Mr. Eiglash's next move is.
Yes, I'm so glad you said that, Matt. I know when I was a prosecutor, that was one of the things I found most frustrating was when my opponents would be able to leave, whether it was a magistrate court or common pleas court, and go find the cameras or the newspaper writers and say what they wanted. And your hands are tied when you're a prosecutor. You have the special set of ethical rules that those attorneys don't have that you must follow, as you know. So thank you for that explainer for us as to why we're not seeing the response from Miami-Dade County on this one.